Good afternoon, everyone. Again, welcome to our webinar on this celebration of HIV is Not a Crime Day, which is technically this Friday. And so we'll get started. As I mentioned before, our webinar is called Visualizing the Threat to Our Communities, New HIV Criminalization Maps from CHLP. I am Kytara Epps, she, her pronouns, and I am the Public Health and Advocacy Strategist. I'm joined here today by Senior PJP Attorney Jada Hicks and Staff Attorney Sean McCormick. All right, so our agenda today is that we're going to provide an overview of the map update process and its origins, introduce the significant changes, explain essential terms for understanding and using the new maps, and lastly, discuss key findings and implications. So just a little bit of background on the Center for HIV Law and Policy. CHLP is an abolitionist legal and policy organization fighting to end stigma, discrimination, and violence at the intersections of HIV, race, health status, disability, class, sexuality, and gender identity and expression, with the focus on criminal and public health systems. In 2025, CHLP is celebrating its 20 years of advocacy, innovation, and unwavering commitment to HIV justice. CHLP is a multiracial organization that uses a Black feminist queer lens to analyze the issue of discrimination, criminalization, and oppression of people affected by HIV and other stigmatized conditions. While HIV criminalization represents a broader impression of people living with or deeply affected by HIV, especially Black people, LGBTQ plus folks, working class folks, people who use drugs, and people who engage in sex work. And while our name focuses on people living with HIV, we acknowledge that many people are living with other conditions such as hepatitis C and other STIs, are punished with severe criminal and other consequences based on their health status. We envision a world free from state violence, where people are not dehumanized and punished for their real or perceived health status and or identities, and where health conditions are not met with criminalization and surveillance and other punitive responses. The Positive Justice Project is a central component of CHLP's work. PJP works with state, local, and coalitions, and people living with HIV, advocates, researchers, nonprofit leaders, government officials, and other stakeholders. Through our work, CHLP supports federal, state, and advocacy efforts, including mobilizing advocates, organizing and strategizing with coalitions, educating stakeholders and policymakers, and drafting policy and advocacy resources. So we're here today to unveil these new maps, but I want to give a little bit about the motivation behind the new maps. One of the motivations, the needs of advocates and our understanding of HIV criminalization have evolved. And with the release of our updated HIV criminalization maps, we want to ensure that people understand the true scope of HIV criminalization across the US. The new administration has attacked science-based information and attempted to erase our communities and our needs. Going back to kind of changing the way our work has evolved, we saw that the old version of our map was maybe too complex, making it harder to quickly understand and convey the realities of HIV criminalization. These laws do not exist in a handful of states. They are widespread, deeply entrenched, and often enforced in ways that are unjust, unscientific, and rooted in stigma. The new administration has attacked science-based information and attempted to erase our communities and their needs, from the gag order on the CDC, the NIH, and other federal agencies, to stripping websites, to the freezing of domestic and international grants. This administration has launched a broad attack on people living with and deeply impacted by HIV. We need accurate resources to ensure that we are able to fight back effectively against state violence, and HIV criminalization can be viewed as the canary in the coal mine. Divestment and disruption of prevention and treatment services makes it more likely that people will acquire HIV but the legal system remains heavily funded. So here's our old map. As you can see, there's a lot going on, array of colors, different icons to pinpoint different components of offenses. So we wanted to change that to make it easier for our advocates and our stakeholders to talk about HIV criminalization. Next slide. So we want to be transparent and give you some information about how we came up with these new maps. Firstly, staff independently reviewed CHLP's HIV criminalization sourcebook and legal databases and classified the laws using a new HIV specificity shading scale. Coding was reviewed through a collaborative gathering of PJP staff who confirmed the categorization and resolved any discrepancies. Lastly, we want to give a big thank you to our comms manager, Dee, who is also working tech right now, who worked with us to create an accessible and visually appealing map for all to use. We want to emphasize that we encourage the broad use of our HIV criminal maps. These maps are designed to support efforts to challenge laws and to inform communities, policymakers, and legal professionals about the landscape of HIV criminalization in the United States. If you choose to use our maps in a presentation, reports, or other materials, please ensure that the Center for HIV Law and Policy is appropriately accredited. Attribution should include our full name and a link to the website or the original source of the map. Additionally, we want to maintain the integrity and accuracy of the information provided. We ask that you do not alter or modify the maps in any way. If you have questions about their content or you would like to collaborate on a specific application, please reach out to CHLP for further guidance. We are sharing the methodology to update the process of our maps because we want to ensure accuracy, transparency, and community engagement in how we track and present these laws. Given that HIV criminal laws are constantly evolving, whether through legislation, policy shifts, or court decisions, we want to make sure that our information is always up to date. So overview of changes. So if you see on the right-hand side, that is our new specificity scale. So the amount of information that we included in each map has been significantly streamlined. Instead of trying to capture all the complexities of HIV criminalization in a single map, we've broken the information down into multiple maps. This approach allows us to present the information in a clearer, more digestible way, making it easier to understand how these laws function and where they differ across states. Moreover, by separating the information into different maps, we can provide a more nuanced and accurate picture of the legal landscape without overwhelming viewers with too much information at once. The maps adopt a new definition of HIV specific and apply a novel HIV specificity shading scale. Later in presentation, Sean will provide a more detailed explanation of this scale, but I'm going to provide a top-level overview. Essentially, the old map did not uniformly recognize the criminalization of people living with HIV through the laws that broadly targeted people living with stigmatized conditions, such as communicable diseases, infectious disease, and sexually transmitted infections. Although the laws that specifically and only name HIV are specifically stigmatizing and dangerous, solely identifying these laws without also including other laws that target people living with HIV through less direct means does not provide a complete picture of the threat of HIV criminalization. Our new maps use HIV specificity scale to identify laws that specifically target people living with HIV and other stigmatized health conditions. By explicitly listing HIV or using these broad definitions, the classification better describes the threat of HIV criminalization to people living with HIV while acknowledging the distinct ways statutes single out people living with HIV. Before we display the maps, what everybody is waiting for, we wanted to share the user guide that accompanies the updated maps. The user guide is designed to help you navigate and interpret the maps. It explains the process we use to update the maps, key changes we made, explains a new and innovative HIV specificity shading scale, and includes essential definitions for utilizing the new maps. To assist you with this rollout of these new maps, we've included portions of it within the presentation. And so you can scan at this nifty QR code that will take you to our maps and our new user guide. And so I'm going to hand it over to my colleague, Jada Hicks.
Yes, thank you, Kytara, and good afternoon, everyone. I'm going to be going over some of the essential definitions that are needed to understand the new maps and really highlight what you're going to be seeing visually as well. So I wanted to just start off with an explanation of HIV criminalization so that we're all on the same page. So HIV criminalization refers to laws, policies, and practices that impose heightened criminal penalties on people living with HIV for conduct that is not criminalized or criminalized less severely for people not living with HIV. Now, these increased penalties could manifest as distinct criminal offenses, such as exposure and transmission offenses, felony enhancements that increase the length of incarceration or fines, forced testing or treatment, or other severe penalties such as registration on the sex offense registration and compliance with extensive restrictions. HIV criminalization also occurs through the general criminal laws. This can look like aggravated assault and battery, which do not specifically mention HIV or another communicable disease, but case law has interpreted these general criminal laws as being applicable to behaviors of people living with HIV. Next slide, please. And so when we're talking about HIV specific, what do we mean by HIV specific? This goes hand in hand later with what Sean is going to be discussing with our new HIV specificity shading scale as well. So a law is HIV specific when it solely names HIV or uses an expansive definition of communicable disease that includes HIV because it imposes criminal penalties or heightened criminal penalties on the behavior of an individual by explicitly singling them out based on their positive status. Now, the terms used to single out people living with HIV are diverse, and the language will vary by state, but can include anything from communicable disease, contagious disease, infectious disease, sexually transmitted infection, sexually transmitted disease, or venereal disease. So these are common terms that we see within the statutory language. Regardless of the exact language used in the law, the effect is the same. Someone's status is used as a means to criminalize them. Next slide, please. So offense. What is an offense? These are laws that impose criminal penalties on people for engaging in illegal activity. If an individual commits a criminal offense, it can result in prosecution and punishment ranging from fines to imprisonment. Any punishment will be specifically outlined in the statutory language. Next slide, please. Enhancement. Enhancements are laws that impose harsher criminal penalties for engaging in activities that are already criminalized. These laws increase sentencing severity or elevate charges based on specific factors, often without considering intent, actual harm, or risk of transmission. When we look at enhancements in the context of HIV criminalization, these enhancements usually apply automatically. So that is, if a person living with HIV is accused of a criminal offense, their charge is elevated solely based on their knowledge of their positive HIV status. These enhancements reinforce stigma and disproportionately impact people with intersecting marginalized communities, Black and Brown individuals, transgender and cisgender women, women who engage in sex work, people who use drugs. These are communities who are historically over-policed already. So these enhancements are associated with certain criminalized behaviors, and we identified 4 categories of enhancements that specifically apply to people living with HIV. So sex work enhancements, syringe or needle sharing enhancements, bodily fluid enhancements, and general criminal law enhancements. So I'm now going to go through each one of those enhancements and give you a brief definition. Next slide, please. Almost every state criminalizes sex work. It's typically a misdemeanor offense. Sex work enhancements impose heightened criminal penalties on people living with HIV for engaging in sex work. A heightened criminal penalty means that an offense that is typically a misdemeanor is elevated to a felony level offense, which can include hefty fines and years-long prison sentences. And they criminalize a broad array of behaviors related to sex work, included engaging in sex work, asking to engage in sex work, agreeing to engage in sex work, or loitering to engage in sex work. Thus, these statutes often criminalize behaviors that pose absolutely zero risk of HIV transmission and do not require an intent to cause harm or transmit HIV. In fact, in some states, this enhancement can apply simply if a person living with HIV has a conversation and agrees to perform a sex act. No physical contact ever has to occur in order for this enhancement to apply. These laws may be part of an exposure or transmission offense or separate offenses. Next slide, please. Nearly all states criminalize the possession and distribution of syringes, needles, or other equipment for drug use through paraphernalia laws. However, it should be noted that some states have exceptions for syringe or needle distribution associated with harm reduction programming. Syringe or needle sharing enhancement impose heightened criminal penalties on people living with HIV who share used syringes, needles, or other injection-related equipment. These enhancements impose felony-level criminal penalties beyond the typical misdemeanor punishment on people living with HIV for sharing used drug use equipment, further criminalizing people living with HIV who use drugs. These enhancements may exist in the exposure or transmission offense or as a separate law. Next slide, please. It is already a crime to expose someone to a bodily fluid. In most states, it's considered an assault and/or a battery. However, bodily fluid enhancements impose additional criminal penalties on people living with HIV who are accused of exposing another person to HIV by throwing, striking, or otherwise causing someone else to come into contact with their bodily fluids. Often, these enhancements criminalize exposure to bodily fluids that pose no risk of HIV transmission, such as urine, feces, or spit. These enhancements are frequently linked to interactions with the criminal legal system, such as an arrest or when a person is incarcerated. They frequently only apply if the alleged victim is a law enforcement officer, correctional officer, or other criminal legal system actor. Next slide, please. General criminal law enhancements refer to heightened criminal penalties for people living with HIV who are accused of violating a general criminal law, such as assault, sexual assault, or rape. These enhancements can show up as separate offenses that have heightened criminal penalties and only apply to people living with HIV. So for example, in Tennessee, a rape is a criminal offense that is classified as a Class B felony. But if a person living with HIV is accused of committing a rape, they will be charged with aggravated rape, which is a Class A felony, so a higher level of felony, which doubles both the fine and prison sentence that can be imposed on a person living with HIV. Again, it doesn't matter whether or not there's a risk of transmission or whether transmission occurs. It's just that the person living with HIV commits a certain offense, it will then be enhanced. These enhancements can also be found in sentencing statutes, such as aggravating factor statutes that result in increased fines or terms of incarceration due to a person's positive HIV status. So for example, in Wisconsin, the law provides that HIV or STI status serves as an aggravating factor for serious sex offenses. So it's going to aggravate the sentence, which may lead to additional prison time. These enhancements also include criminal penalty enhancements that don't fit into other categories of enhancements. Next slide, please. People convicted of an HIV criminalization offense may also be required to register on the sex offense registry, with some states requiring lifelong registration. People registered must comply with extensive reporting requirements and refrain from living, working, and even existing in certain spaces. Exposure, transmission, and non-disclosure offenses are often used interchangeably within our work. However, typically these are separate and distinct offenses, and you must look closely at the statutory language to interpret which activity is being criminalized. So an exposure law imposes criminal penalties on people living with HIV for engaging in specific behaviors that purportedly create the possibility of HIV transmission, such as having sex or sharing syringes, or more broadly, exposing another to HIV through any means or conduct. This does not mean that there is an actual risk of transmission, but instead the focus is on the perceived risk of transmission. Whereas a transmission law imposes increased criminal penalties for the transmission of HIV from one person to another. That is, the law requires seroconversion. Lastly, non-disclosure laws. While many states impose criminal penalties for exposure or transmission, some states additionally impose criminal penalties on people living with HIV for non-disclosure of HIV status to their sexual, drug use, or other partners. That is, these states criminalize distinct behavior. For example, Indiana has a duty to inform law. People who do not fulfill this duty to inform are punished through Indiana's failure to comply law. I'm now going to pass it over to my colleague, Sean, who is going to debut the long-awaited maps. So Sean, take it away.
Thank you, Jada. And the moment y'all have been waiting for. We'll start with our first map, which is the exposure or transmission map. So using the new methodology, there are 32 states with an HIV-specific exposure or transmission offense. That is, 32 states have laws that directly or indirectly single out the behavior of people living with HIV for criminal punishment. On the right, there is the new HIV specificity scale, which is broken down into 4 categories. For this offenses map, 14 states have offenses in which HIV is specifically named in the offense and no other disease is listed. 4 states have offenses in which HIV is specifically named alongside other diseases. 5 states have offenses that use the term communicable disease or something similar. The law in these states clearly considers HIV one of these communicable diseases. And finally, 9 states use the term communicable disease in the statutory, administrative, or case law definition of communicable disease is likely broad enough to include HIV. In applying this new specificity scale, the map recognizes that even in states that no longer have the most specific HIV offenses due to legislative reform, such as California and Virginia, the threat of HIV criminalization still remains. And for states that have historically used communicable disease language, such as Rhode Island or Minnesota, this map also identifies this ongoing threat. Geographically, although concentrated in the South, we see that these offenses exist across the United States. We see that many of the most specific offenses, the laws that specifically and only name HIV as a criminalized condition, are present in the South. But there are other examples in the Northwest and the Midwest. Again, it's important to reiterate the racist, sexist, homophobic origins of HIV criminalization. These states use that most specific language to target and stigmatize folks living with HIV through the law and codify this stigma in the law. It's also critical to note again that this map only accounts for HIV criminalization through these HIV-specific offenses. People living with HIV may also face criminalization through the use of general criminal laws that do not specifically mention HIV or communicable diseases. As Jada mentioned, prosecutors across the United States have leveraged general criminal laws, including aggravated assault, reckless endangerment, and attempted murder offenses, to impose criminal penalties on people living with HIV for conduct that is not criminalized or criminalized less severely for people not living with HIV. It is exceedingly difficult to comprehensively track these prosecutions using general criminal laws. However, CHLP has relied on legal research, namely case law research, coalition contacts, news reports, and social media to conclude that general criminal laws have been applied to perpetrate HIV criminalization in every state of the United States. Finally, on this map, I want to mention that we plan to come out with additional maps to explain other behaviors that are punished through HIV-specific offenses. These will include offenses that impose criminal penalties on people living with HIV for attempting to donate organs, blood, plasma, or semen, as well as some additional maps about reform. I'll move on to the next slide, which highlights sex work enhancements. This map is one of 4, as we mentioned, that separates enhancements from the offenses map. In distinguishing between the enhancements, we're able to more fully describe the gamut of behaviors that are disparately punished for people living with HIV. The threat of HIV criminalization is nuanced, especially for communities with intersecting marginalized identities, such as LGBTQ people who use drugs, Black and Brown people who engage in sex work, and these enhancements do a better job of describing this threat. For the sex work enhancement map, we see that these enhancements are predominantly in the South and Midwest. All of them specifically and only target people living with HIV. This sex work enhancement map really shows how sex workers living with HIV are so precisely targeted by HIV criminalization and these HIV-specific offenses, or enhancements, excuse me. These laws represent some of the most direct, intense attacks on people living with HIV, and these enhancements are a codification in law of stigma against people living with HIV and sex workers, especially sex workers living with HIV. In the next map, we have bodily fluid enhancements. Similar to the sex work enhancement map, many of these enhancements are concentrated in the South and the Midwest. And as Jada noted, these enhancements are commonly tied to criminal legal system involvement. Many of these states also have some of the highest rates of incarceration, especially for Black and Brown folks, which in turn increases the likelihood that people will be charged with these enhancements. Moreover, while most enhancements and offenses have the highest HIV specificity, we see that with these bodily and fluid enhancements, it's common to criminalize people living with other stigmatized conditions, such as viral hep or tuberculosis. The next map describes general criminal law enhancements, and this is perhaps the most geographically diverse map. These enhancements are range from the least specific enhancements in Massachusetts through enhancements in Illinois and Wisconsin and Indiana, all the way to California and Alaska. I'll continue with our last enhancement map, which is our syringe and needle sharing map. These enhancements add on to the existing drug criminalization scheme that is pervasive throughout our country. Like many of the other maps, these laws are concentrated in the South and Midwest. And to summarize the important changes across these maps, as well as the offenses map, we see that there are fewer patterns and more streamlined information, which make the maps easier to understand. Similarly, the maps are now divided into these offenses and enhancements. As we mentioned, these allow for a more nuanced discussion of the targeting of marginalized folks, such as people engaging in sex work and using drugs. And the new HIV specificity scale allows for a more detailed description of the targeting of people living with HIV. We do have some final advocacy thoughts that I'll end with in a minute, but I want to directly say what the new maps mean for advocates. They mean that there's increased accessibility for these maps. And more directly, it'll help in advocacy settings, especially lobby days or legislator meetings. These maps are better suited for smartphones, as well as better suited for slide presentations to specific stakeholders. The new maps also allow for improved understanding of the threat of HIV criminalization in its diverse forms. Specifically, the HIV specificity scale and the enhancement maps help with this. The improved understanding should lead to more effective advocacy that centers the experiences of impacted people, especially people who are most impacted. And continuing with some next steps for advocates. We recognize that many people use these maps for non-advocacy purposes, such as for training of health professionals, education and support for people living with HIV, and additional policy and legal research. But we also intend for these maps to be an advocacy tool for justice. So we have some final thoughts for folks hoping to bring about justice for people living with and deeply impacted by HIV. We encourage you to use these maps to fight back against erasure of our communities and the dismissal of the harms of HIV criminalization and other state violence. We must remain committed to moving forward and never backwards, and we must find hope and comfort in our people in the fight against oppression. These maps are also a critical educational tool for legislators and other policymakers, as well as community members. We encourage you to raise awareness of HIV criminalization, its large scope, and its destructive effects. Similarly, these maps can rebut misinformation that dismisses the impact of HIV criminalization. We encourage you to use the maps to identify areas for change. It is likely that your state has an HIV-specific criminalization law, and basically every state allows for general criminal laws to be used for HIV criminalization. Use these maps to mobilize community and create a movement to end HIV criminalization in your local setting. These maps will provide clear and concise information to aid these efforts. Lastly, the resources have been designed and crafted in response to local advocates. We ask that you communicate with us about any suggestions you have for these maps. And beyond the maps, we are here to provide tailored legal and policy support for you. As Kytara mentioned, this plugs our user guide. I encourage you to scan it. I will return back to that. I want to also just, before we move to questions, plug a couple extra resources that were name dropped and may be helpful for you as you do additional research. Our source book is the most comprehensive guide to HIV criminalization laws throughout the country. I encourage you to scan this QR code and use it as a resource moving forward. Additionally, if you would like to become involved with the Positive Justice Project, which is the first national coalition aimed at supporting state and local coalitions reforming or repealing their HIV criminalization laws, we encourage you to join the National Coalition of HIV Decriminalization Advocates. I'm going to jump back to the user guide as we turn to questions now. We are very open to any questions or thoughts that y'all have. Please feel free to add them in the comments and we will get to them.
Our first question is from Nathan, and it's asking, where can we find the new maps from CHLP homepage?
Yes, they are posted on our website, and we can have Dee, who is running tech and handles our comms, put the link in the chat for you, Nathan, but they are live on our website.
Our next question comes from Adrian. Is there any available info on the number of cases related to HIV criminalization in the US? Something to help visualize how laws are being used.
I love that you just asked that after Nathan asked a question, because I'm going to plug Nathan's org really quickly in terms of number of cases related. So it is very hard to track HIV criminalization cases. I think you may have heard Sean mention, like, specifically when it comes to general criminal laws, you know, we've relied a lot on case law, media reports, coalitions to get that information. There are a number of states that the Williams Institute has done. They're a part of UCLA Law School, where they have basically gone in and requested the data on a county level in order to learn who is bearing the brunt of prosecutions. And so if you check out their reports, now, while they do great work, it is not every state that has an HIV criminal law, because these reports take massive amount of time. Thank you, Nathan, for putting that in the chat, but it's the state level reports that will outline, you know, which statute someone is being criminalized under, how many cases. It will break it down by race, gender. It will also have the enhancements in there. So all of that information is encapsulated within the reports. I strongly encourage you to not only visit the website just for your edification, but if you're doing any sort of advocacy work, to reference these reports. I know CHLP often, and a lot of the coalitions that we work with, often rely on these reports to speak to legislators about the overall impact about HIV criminalization and to show just how discriminatory these laws are. I know Sean and I both touched on how a lot of these laws and enhancements specifically apply to Black, Brown communities, trans communities, those who inject drugs, sex workers, and immigrants. And so a lot of that we heard anecdotally, but Nathan and his team's reports out of the Williams Institute, we were able to back that up with data and statistics, and it's really highlighted and the trends are shown in their reports.
Thank you, Jada. We have a question from Terry. Do you have any data on how many people with HIV over the age of 50 have been prosecuted, charged, or placed in prison by any of these laws? I'm having a hard time finding this information.
Let me first start by saying that we appreciate your concern in finding that information and the difficulty in finding that information, because it is something that's hard to find. I would again point to the Williams Institute reports. I'm not familiar with any analysis that they've done on age characteristics. I think Nathan's adding some information in the chat, but I will point you all to a specific resource that's come out in recent months, put out by Kay Greenberg, who is an attorney at CHLP. This resource specifically focuses on the needs of people living and aging with HIV. A dedicated portion of this comprehensive resource looks at some of the impacts of aging with a criminal record and some of the special considerations that folks must consider.
Thank you, Sean. Our next question is from Omar. I work in a community with health, and historically I have been told that my team is not allowed to lobby because of our funding sources. I wonder if you can share ideas for advocating in clinics or during community events.
Yeah, so it's my understanding is not, as long as you're not saying whether or not someone should vote for a piece of legislation, it's not lobbying. So you can still do education and advocacy within the clinical setting, as long as you're not trying to tell someone like, you should vote this way on this piece of legislation. And so I think something else that I want to reference really quickly that our other staff attorney Kay engaged in was a model policy that may be helpful in clinical settings. I don't know if you could maybe put that in the chat as well, but anything about like hosting and training webinars. So you can organize sessions for healthcare providers on HIV criminalization, stigma, and best practices. So that's a huge way that you can engage in this work without lobbying. I think you can even distribute materials from organizations and share research and guidelines. So if there's something on CDC, CHLP, or other public health institution websites that emphasize any sort of evidence-based policies and approaches. And not only that, but presenting statistics alongside patient experience to really highlight gaps in care and the impact of criminalization on health outcomes. So I think that that's something that you can utilize as well. In reference to the policy, the model policy on data privacy, while that's not directly HIV criminalization, because we know everything intersects with HIV criminalization, it could tie in if that information is then released and used in a prosecution. So there are other ways to advocate that aren't directly HIV criminalization work, but tie in and intersect with that work. So advocating for confidentiality protections, so in encouraging any clinical setting that you're in to strengthen policies that protect patient privacy, but particularly regarding their HIV status. So I think those are all ways that you can really engage in this work. I see Eric from Sero saying like anything around education. So I think also anything that reduces stigma as well. So going through your own resources within the clinic, looking for any stigmatizing language, updating and removing that language, and anything from like encouraging routine HIV and STI testing is also a form of advocacy. So I'd want to name that, like, let's not forget that that is advocacy work as well.
Thank you, Jada. Our next question comes from Kennedy. Are there any additional resources for how people living with HIV can defend themselves against these laws, or how to confront those who who are fearful?
I'm happy to jump in because this is a concern that many people have about HIV criminalization laws. Like, given the current situation that we're in, how do we move from here? How do we live our lives and make sure that we're not criminalized? We do develop resources and on a state-specific basis to educate folks about what their law is, and then also provide information about what that means for how they can protect themselves, whether it's through sexual encounters or drug use encounters. That's something that we continue to develop for coalitions upon request. I also know that there are other resources put out by other organizations, such as Positive Women's Network, that specifically acknowledge some considerations for women and femme folks when it comes to HIV criminalization. I don't know if Jada, if you have anything additional to add.
No, I think also just reaching out, because like Sean said, some of these resources may exist in your state. Kennedy, I don't know which state you're in. If not, we're happy also to create something for you. I know our Know Your Rights palm cards a few years ago were wildly popular, and happy to distribute those again as well. And yes, please reach out if you need any assistance with that.
Our next question comes from Kenjo. I hope I'm pronouncing your name correctly. Thanks so much for this great presentation. I've learned a lot. Do you have insights on how this impacts people living with HIV under the age of 18? For example, how does this connect to the school to prison pipeline?
I'll start by saying that we strongly believe at CHLP that HIV criminalization fits into the broader criminalization of people with certain intersecting marginalized identities. So specifically, we believe that HIV criminalization represents a racist and sexist practice that continues to marginalize Black and Brown communities, people who use drugs, people of working class backgrounds. So this is something that we definitely grapple with at CHLP. I think we haven't drawn that connection explicitly through a resource or through a conversation, but I think that's something that we can additionally explore.
Yeah, I just wanted to add that I imagine that we would see a parallel in the racial disparities that we see in HIV criminalization cases, as well as the school to prison pipeline. I imagine there would be a lot of parallels there, but it's not something that we, again, have specifically researched. So I don't know that I can speak much more to that, but I do think that that is a great question. So thank you.
I have a question. What were some of the biggest challenges in redesigning the maps?
Yeah, I'm happy to start with them. I'd love to hear your input as well, Sean. But I think one of the biggest things that we talked about in doing this was like striking the balance between legal accuracy and accessibility. So I feel like Sean and I had a lot of Zoom calls where we were really trying to figure out, okay, how do we make sure that in making this information more digestible, we're not actually taking away any of the substance. There's this really delicate balance of making sure that we're describing things in a way where it's accessible to everyone, to any audience, but also making sure that we're not changing the rule of the law or tweaking it in a way that is a misrepresentation. So I feel like there was a lot of back and forth about how to do that and accurately convey the information. I don't know, Sean, if you have anything else to add to that.
I think generally it was a lot of information to process from 50 states plus additional territories. In developing the scale specifically, that is not something that we had done before, the HIV specificity scale. So coming up with uniform definitions for each of the categories in a way that didn't overlap and would allow for, better depiction. Another thing that I will point out is that I know she already got a call out, but Dee Resnick, who does our communication support, she has been a tremendous resource in developing the resource in a way that the maps in a way that is visually appealing and does have improves accessibility when it comes to pulling up the resource on your phone in other settings that maybe are non-traditional and not something that when the maps came out initially that we were thinking of.
Great. We have a couple more questions in the chat from Humberto. Thank you for the rich presentation. One burning question, are there materials in other languages?
We are working on that. It's something that we've been trying to be more and being more accessible, make sure that it's available in other languages as well. So please stay tuned for access to the materials in other languages.
Okay. And then the next question is, and you kind of hinted at it, Sean, from Ben, DC has very high rates of HIV, stigma, et cetera, as does Puerto Rico. Are there any plans to incorporate territorial laws, or would they be too complex?
It's definitely not too complex, and it also is very important that we acknowledge folks living in Puerto Rico, DC, and other territories. So we do have analysis on those states as of now. Within the source book, we do include U.S. territories as well as DC. On this map specifically, I believe that we don't have DC pictured, but within the source book, we do an analysis of those HIV criminalization laws. I would also encourage, if there are specific questions, to reach out to us. We do consult with folks in the territories. They've reached out to us before about specific questions that they have in resource development. So that's something that we may already have on the books that we'd be happy to share if there are specific questions.
We have a question from Diego. Do HIV crim protections apply when someone is presumed HIV positive, but is not? It is used to be true, but I'm not sure now.
I hope I'm going to answer this question appropriately. I think the wording is throwing me off just a smidge. So if someone is presumed HIV positive, but is not, they wouldn't be subject to any criminalization anyway, because the first element of almost every HIV criminal offense is knowledge of your HIV status. And you have to be HIV positive for those laws to apply. I hope that appropriately answers the question, Diego. Please put something else in the chat if it does not.
Another question I have is, how often will the maps be updated?
We intend for these maps to be updated frequently based on developments and laws and policies across the U.S. We do a review every year of what has changed based on our involvement with coalitions across the U.S. as well as additional information, but additional information that we get from some of our partners. So our intent is to maintain this the maps by updating them every year. I'd also say that our understanding of HIV criminalization does evolve, as we've seen with this new substantial update that we have. So there may come a time when these maps need to be updated to more accurately reflect, the way that HIV criminalization works in future years.
I also just want to point out to you something that Sean named earlier in his portion of the presentation was like, if there's ever anything that you have questions about or you think needs to be updated, or there's a change that's made in your state and you don't see it reflected yet, please reach out and email us. We are a small but mighty team, so not everything is going to be immediate after legislation is passed. It's going to take us some time to make those changes and updates. But if you think that there's something and you want to flag it for us, please feel free to do so. We do encourage that community input and outreach as well.
All right. Okay, Diego asked a follow-up question. Thank you. In the documentary film Baby by Sean Strub, it was mentioned that someone was arrested but not tested. It was 2011. I think the question is pointing like, can you be arrested on suspicion of having HIV?
Yeah. Okay. I understand now, Diego. It's basically like if someone makes this accusation, but they don't know your status yet, I think is what the question is. So yes, of course, I think unfortunately that could happen. Someone can make a claim and allege that you committed some crime. And unfortunately, with the way our criminal legal system works, that could result in arrest before they have your HIV health information that shows that you're negative. So if Sean was talking about that, Sean Strub, not CHLP, Sean was talking about that in a documentary, that might have been what he was referencing. And it's unfortunate because that person would then, miss work, maybe not have childcare while they were arrested, maybe have to pay and post bail. But ultimately, I think in that situation, the charges would be dropped because they wouldn't be HIV positive and they wouldn't be able to proceed. The state wouldn't be able to proceed with prosecuting that individual. So those are two separate things. But I do think that there could be an instance when there's poor police work and someone could be arrested without, with a claim that they are HIV positive when they are in fact not. I think I understand now. Thank you for clarifying.
Thank you. Another question is from Gerald. What innovative strategies can communities, activists, and policymakers employ to reform or repeal HIV criminalization laws to support better individuals living with HIV in the southern regions? How can allies and advocates effectively mobilize public opinion and political action around this issue? Before I hand it off to our two lawyers, there's a lot of great Southern advocates on this call right now. I've seen lighting up the comment section. So if y'all feel free to also answer Gerald's question. I think our advocates that we work with on this state level and in coalitions are just a bevy of knowledge, and that's whose work we're supporting.
In the meantime, I would like to point out as well that Kytara and I have really been engaging, and this specifically goes to the southern region, expanding our work with faith leaders. So I think trying to get involved with unconventional allies and bringing them into the conversation, and really looking at how they can myth bust and, instead of reinforcing stigma, really break this cycle of stigma. So that's something that's really, really important, specifically in southern regions. I think also, Georgia reformed within the last few years, and they relied a lot on the Williams Institute report and really coalescing as a coalition around the discriminatory impact and effects of the law in order to get reform efforts. So I think really having great relationships with sponsors made that possible. Utilizing their network made that possible. A lot of education, lobby and Hill days to educate legislators on HIV and stigma. That's something that has been successful. In the South, sometimes you have lunch and learns. I know that's not particular to the South, but they may work better, lunch and learns, where you're in person and you get to sit down and speak with the legislators as well. So there are a number of different strategies that you can employ in order to try and engage in this advocacy and take political action to mobilize and change public opinion. Depending on the makeup of your legislature, personal stories are sometimes helpful. I think that's really when we rely on grassroots advocates on whether or not that is something that's going to sway public opinion or not. But if not, sometimes data and science will. So utilizing our resources, as well as any other resources you can show. So the Williams Institute reports, we have a reform timeline that is actually going to be updated as well that could be utilized, these maps to show a national perspective. I think there are a number of things that you can do to mobilize. I don't know if there's anything else or if anything has come up in the chat or not, Kytara.
I'd like to call out just another state, and I just saw that Dietz dropped a comment in the chat, but a lot of what people focus on is legislation, but it's a lot of background work in building a movement within a state. And specifically, I'm thinking about Louisiana, which is the Louisiana Coalition on the Criminalization of Health. And their work in the next year will be focused on the coalition and building out relationships to where they are prepared for legislation coming further down the road next year, years beyond. And that includes building relationships with folks that you may not traditionally think of having relationships with, but those folks are going to come up. So maybe it's law enforcement or sexual assault survivors groups. These community relationships are going to be pivotal when a bill does come up. So building relationships and connecting on that personal story, as Jada pointed out, is something that will be useful. The other aspect of it is investing in the people that are involved within the coalition. So investing in coalition members to make sure that they are taken care of. People living with HIV should be driving any coalition, and their needs should be addressed as a primary objective of the coalition. Their immediate needs. Yes.
And then we're going to take this last question from Tare. Do you think the executive orders are meant to criminalize a lot more people? Funding, and also criminalize people who release funding, implement DEI programs as they pertain to the HIV community.
So executive orders aren't going to directly criminalize people living with HIV in that way, but I do think that there are ways in which they could contribute to policies that result in the criminalization of people living with HIV. So, for instance, more policing and surveillance of marginalized communities, making people more vulnerable to arrest and prosecution under existing HIV criminal laws, I think is a huge one. But there's not going to be a call for like directly some sort of criminalization within that way, couched within an executive order. I think another thing that we can see and that we have seen is like the weakening of initiatives that support people living with HIV. Specifically that support Black, Latina, LGBTQ+, and other disproportionately affected communities. I think that we will continue to see that. And we've already seen that that has reduced and or eliminated access to HIV prevention and treatment as well. So in turn, while I don't think it's direct, remember that if people aren't on treatment, depending on the state that they're in, it's going to make it so that they, one, cannot achieve viral suppression. And they are not going to be connected to care. In certain states, very few, I'm thinking of North Carolina, whether you are virally suppressed means you actually can't face criminalization within that state. So they could not have access to the defense in North Carolina if they're not on treatment, not able to achieve viral suppression. Not many states have that written into their law. So I want to add that in as an exception, not the rule, but I'm just kind of thinking out loud about how executive orders could interface with HIV policies. I don't know if there's anything else that anyone else would like to add.
All right. This has been such an enlightening webinar. Some really great questions. And yeah, so we're gonna wrap up now. And again, thank y'all for hanging around. We had 150 people join us at one point. And so thank you for taking out time from your lunch throughout your day and joining us to unveil these really much needed resources for our communities. And with that said, please go about your day and enjoy.